Hello, my name is Attorney Paul Chang, and this is another session of Ask the Attorney. Wanted to thank all of you for being here, but most importantly, I need you to go to the first video that tells you essentially that this does not create an attorney-client relationship. Today's question is owner responsibility for actions of his or her employees when the employee essentially signs a contract with someone else, and that third party wants to enforce the contract against the corporation. Dear Attorney Chang, Jack was an employee in our company. He entered into an agreement with another company. We did not authorize him to do so. When we were alerted to the contract, our employee admitted that it was his mistake and he would take care of it. We never expressly told anyone that we would accept the contract, but now we're being sued for breach of contract. Is there anything that we can do? Sam and San Marino. Well, Sam, I understand your frustration. The two main issues in terms of ratification, which is the law behind this, is this. One, you need to know of the situation, and two, you need to have received the benefit of the situation. Now, what does that mean? What does ratification mean? Ratification essentially means that you agree, whether expressly or impliedly, to the terms of a contract that you did not necessarily sign. So let me give you an example. Let's say that Joe, who works at McDonald's, enters into a contract to serve Coca-Cola products for McDonald's. Now, Joe is an average person. All he does is he works at the drive-thru. Well, if McDonald's comes in, looks at the contract, knows of the contract, and begins to sell Coca-Cola products, and then Pepsi is subsequently brought in, and Coca-Cola says, hey, wait a minute, you went into an agreement. McDonald's cannot say that the CEO of McDonald's did not sign the contract, and therefore McDonald's is not responsible. The argument would be here that McDonald's essentially accepted the terms of the contract. They knew about the contract, received the benefits of the contract, and therefore Pepsi has a good lawsuit against them. Well, in this case here, what we would ask is, did you, Sam, know of the agreement? And your answer is, yes, we knew of the agreement. The second thing is this, did you receive the benefit of that agreement? And if you did, I would say that there is potentially a good cause of action for breach of contract. Some quick factors that I'd like you to think about is, one, when did you find out about the contract? Two, could you have done more instead of just having your employee take care of it? Three, what is Jack's position? Is Jack just a regular employee, or is he a CEO, or is he somebody that has authority? Four, what were the terms of the contract? Five, were they beneficial to you? Six, would a reasonable person under the circumstances acted the way that you did? And seven, did you terminate the employee as soon as you found out that the employee had a contract that essentially violated the principles of your corporation? And all of those factors put in essentially creates the rule of ratification, which states that if a corporation ratifies the actions of their employees, the corporation must be liable in case of a breach of contract, even though the corporation did not specifically enter into the contract. Thank you very much and take care.